Hello, and thank you for joining us in this discussion on how South Asian and Southeast Asian diaspora communities in Europe can leverage the rights afforded to them by the Digital Services Act to address online harms, including hate and disinformation, both within Europe and originating from other regions globally. My name is Naila Mohammed. I'm the Director of Research at the Center for the Study of Organized Hate. And previously, I served as a Senior Policy Analyst for South Asia at the U.S. Commission on International Religious Freedom. I'll be your moderator for today's event. The rise in hate speech targeting South and Southeast Asian communities in the EU is both complex and transnational. These communities often face dual pressures. On one hand, from domestic anti immigrant sentiment and far right groups within Europe, and on the other hand, from coordinated hate campaigns and extremist content originating in their countries of origin. Increasingly, the far right and religious extremist ideologies in South Asia are being decimated online and reaching diasporic audiences around the world, including Europe, where they risk radicalizing segments of these communities through social media and other digital platforms. This poses a serious threat to social cohesion and intercommunity relations. The 2022 Leicester violence in the UK, where tensions between local Hindu and Muslim youth escalated into street clashes, underscored how transnational digital disinformation and imported hate narratives can ignite real-world conflict within diaspora groups. In multiple cases, diaspora voices, including Indians, Pakistanis, Bangladeshis, and others from Southeast Asia, who are critical of political developments or policies in their home countries, have become targets of online harassment, smear campaigns, and disinformation attacks orchestrated from abroad. These transnational campaigns amplify fear, silence dissent, and undermine the safety and cohesion of increasingly vulnerable diaspora communities across Europe. This is the landscape the EU Digital Services Act is designed to address. The DSA is a landmark regulation that establishes a harmonized framework for regulating online platforms and content moderation across the EU. At the core of its enforcement mechanism are digital services coordinators, DSCs, which are national level regulatory bodies designated by each EU member state responsible for overseeing platform compliance, addressing user complaints, and coordinating with the European Commission. The DSA also introduces the concept of trusted flaggers, entities with proven expertise in identifying illegal content, whose reporting platforms must prioritize and act on quickly. Platforms are required to implement a notice and action mechanism that allows users or trusted flaggers to report potentially illegal content. Once notified, platforms must assess it, and if necessary, remove the content swiftly and transparently. The DSA also requires platforms to offer access to out-of-court dispute settlement mechanisms, allowing users to challenge content moderation decisions through certified independent bodies. Today's session, organized by the Center for Organized Hate and FactReview, and joined by members of civil society organizations and researchers in Europe, South Asia, and Southeast Asia, will explore how the enforcement mechanisms of the DSA through DSCs, trusted flaggers, and dispute resolution bodies can be activated to protect diaspora communities from these intertwined online harms. Our speakers will unpack each of these roles and offer concrete guidance on how civil society actors and individuals can engage with them. Now, before we begin presentations and introductions, a quick reminder, if you have any questions for our panelists, please feel free to submit the question answer function on Zoom at any point of the session. We'll address as many questions as we can during the portion we've dedicated to it at the end of the event. Now, moving on to speaker introductions, we have Ioana Hudalaki. She's the head of the Digital Services Act team at the Greek Telecommunications and Post Commission. She is also the head of the newly established Directorate for Digital Services. Since 2016, she has been a drafter in the body of European Regulators for Electronic Communications, Roaming Working Group, where she supported the implementation of Rome Like at Home. And in December 2018, she was appointed co-chair of this working group. In 2023, Ioana was also part of the BEREC chair team. She was the chair of the BEREC Contact Network. Next, we have Andronikos Kotrompailis. He's been working with a fact-checking network since 2018. In 2019, he took part in the launch of a meta fact-checking program in Greece. In 2024, his new organization, FactReview, became the first EU DSA-recognized trusted flagger in Greece. Andronikos has been working on cross-national programs, fact-checking investigations, media, AI literacy, tech tools, and DSA oversight. Nicholas Eder is a co-founder and COO of User Rights. He is also a visiting lecturer at King's College in London, where he teaches the course Technology, Democracy, and Society. Previously, he worked as a senior policy officer at the Oversight Board and as a postdoctoral fellow at the Center for Socio-Legal Studies at the University of Oxford. Nicholas was also a fellow at the Information Society Project at Yale Law School and a visiting scholar at Columbia University. I'm going to move on next to our panelists' presentations, and we'll first start with Ioana. Ioana, would you like to start with your introductions?
Of course. Many thanks for the introduction and many thanks for inviting me to participate in this online event of the Center for the Study of Organized Hate to discuss about the tools that the DSA, the Digital Service Act, can offer for combating illegal content online. Let me first start by giving you an overview of the regulation and then trying to explain how we are implementing this regulation in practice in Greece and in Europe, because we are part of this European network of digital service coordinators, and give some background information, and then we can, of course, I can, of course, answer to any questions you might have. First of all, let me tell you that the DSA was published in October 2022, and as of the 17th of February 2024, the DSA applies to all platforms. Since the end of August 2023, these rules had already applied to designated platforms with more than 45 million users in the European Union, which is in practice around 10% of the EU population. And these platforms are called very large online platforms, VLOPs, or very large online search engines, VLOSs. You might have heard these terms. They are quite commonly used in the DSA ecosystem. In addition, these very large providers, for which the regulation started to be implemented earlier, they have also additional obligations that require them to take more proactive measures against systemic risks. For example, these are risks related to the dissemination of illegal content through platform services, or risks related to actual or foreseeable negative effects for the exercise of fundamental rights. DSA, in practice, introduces obligations to all digital services with the aim to increase transparency and introduce procedures to tackle effectively illegal content online. Providers of digital platforms shall communicate points of contact that will allow users and authorities to reach out to them. The platforms shall publish the terms and conditions in clear and user-friendly language without creating ambiguities to users. They shall put in place mechanisms that users can easily use for reporting illegal content. They are obliged to give priority when examining content being flagged as illegal by trusted flaggers, like FactReview, like Andronikos will explain how this works in practice. They have to provide clear and specific statements of reasons for their content moderation decisions and give users the option to appeal against these decisions. Furthermore, these platforms have to ensure that users are informed about the main parameters used in the recommender systems and about the options that users have for modifying these parameters. And they have to ensure a high level of privacy, safety, and security for minors that are using the services. This is a very important aspect, and currently there is an important consultation on behalf of the Commission about specific guidelines on how to ensure the protection of minors. In addition to all the above, specifically for very large online platforms, the very large online providers, the ones with a number of users above the threshold of 45 million users, in addition to the above, they have to assess regularly the systemic risks that stem from the design or the functioning of the services. These VLOPs and VLOSs have to introduce measures to mitigate these risks. For example, they have to adapt their functioning if they see that this functioning creates risk. They have to adapt their content moderation systems. They might need to increase transparency, adopt codes of conduct. The regulation includes various examples of how these risks can be mitigated. And they have to give access to vetted researchers to the confidential data. So these are researchers from academic institutions that are allocating resources to make research specifically target on systemic risk. So these researchers can apply for getting the status of vetted researchers, and then these very big platforms have to give them access to the confidential data that will support the research. So this is a very important aspect, and it hasn't started yet because the Commission is going to issue specific rules about how this will be processed, and these rules are about to be published. So very soon we will start having the first applications, and then we will start having the first results on behalf of these researchers. So this is a very important element of the regulation. As just mentioned in one of the points about the specific obligations for VLOPs, one important aspect of DSA is the introduction of code of contacts under DSA. These, although foreseen in the DSA, are voluntary initiatives that can address online issues such as illegal content and systemic risks by fostering collaboration among stakeholders. Under the DSA, codes of contact can help stakeholders to adopt commitments contributing to the application of the DSA. Codes of contacts may also include additional reporting commitments complementary to the ones imposed by the DSA in order to enhance transparency on measures taken by digital platforms. In addition, the codes of contact provide a forum for exchange among platforms of different sizes because they are signed not only by VLOPs, but also by smaller platforms, civil society organizations, researchers, and other stakeholders. And this will help to have the signatories accountable to their commitments. Moreover, these codes allow smaller platforms and civil society organizations to actively contribute to the exchange of best practices, which is a very important element, of course. Since February 2024, two codes have been adopted. The first is the Code of Conduct on Countering Illegal Hate Speech Online, which is relevant to what we are discussing today, which seeks to prevent and address the spread of illegal hate speech on online platforms through commitments in the areas of terms and conditions, review time of notices, transparency of content moderation actions, multi-stakeholder cooperation, and awareness raising. So this code covers all these areas and facilitates the effective enforcement of the DSA in this specific area. This code has 12 signatories, and 7 of them are very large online platforms. It's Facebook, Instagram, LinkedIn, Snapchat, TikTok, X, and YouTube. Moving now to the other code of conduct that was also adopted recently is the Code of Conduct on Disinformation, which seeks to combat disinformation through commitments made by online platforms, players in the advertising industry, fact-checkers, research and civil society organizations in areas such as demonetization, political ads, fact-checking, user empowerment, and others as well. This code has 40 signatories, including VLOPs, VLOSes, as well as other players in the digital ecosystem, not only platforms, but also the other stakeholders. So these are the two code of contacts that are important and relevant to the discussion we are having today. Coming now to the enforcement that we do as the Greek Digital Service Coordinator, let me describe you how we have been working since April 2024, when we were officially designated, and to also refer to our future work plans. Our work focuses on two pillars. First, the first pillar is the enforcement of the rules on providers established in Greece. Firstly, we want to map all the relevant Greek providers and make them aware of their obligations in order to monitor their compliance with the rules. At the same time, we focus in promoting the involvement of Greek bodies like trusted flaggers, out-of-court dispute resolution bodies, and researchers in the implementation of the rules. So these the bodies established in Greece that can have a role in this respect is quite important for us to also have Greek-speaking, established in Greece bodies that can contribute, because these bodies can also contribute when it comes to the Greek content. We already have 3 trusted flaggers that contribute in the quick removal of illegal content from platforms, and we are almost ready to award the out-of-court dispute settlement body status in one body that has the required expertise. Moreover, we are in continuous exchange with other Greek authorities that monitor the dissemination of illegal content online, like, for example, the cybercrime unit in Greece. The second pillar concerns our contribution in the proper enforcement of the rules for very large platforms, very large providers. Although the European Commission is the authority in charge of monitoring these very large providers, similarly to other coordinators from other countries, we try to fit this work with input we collect about systemic risks or about alleged non-compliance observed by very large providers. We usually collect this input from other Greek authorities, from our trusted flaggers. We have a very good cooperation, for example, with Andronikos, and from the complaints we receive from Greek recipients of services. We are in a frequent contact with all these players, and for the coming months, we want to make this exchange more systematic and also involve civil society organizations with which currently our cooperation has been more sporadic. As TSE also recognizes, the contribution of civil society organizations is of paramount importance for the effective implementation of this regulation. Moving now to the specific topic of today's discussion about how South Asian and Southeast Asian diaspora communities in Europe can leverage the DSA tools to combat and prevent online harms, and take into consideration what was just presented about DSA, I see some areas which can prove helpful for these communities. Firstly, the use of the notice and action mechanisms foreseen in Article 16 of the regulation. This is a tool that members of these communities should be encouraged to use and in order to report to platforms any content that is considered harmful. And they should also be aware that if their notice is not handled in a way they would expect, they could also lodge a complaint addressed to the platform. If the issue persists, they could also contact the Digital Service Coordinator in their country of residence within Europe and submit a complaint. And this information will be forwarded to the relevant enforcement authorities. In addition, these communities could also try to cooperate closely with CSOs that are focusing on the relevant issues. The civil society organizations are having an active role when discussing about systemic risks and could contribute in a more proactive way also in the context of the codes of contact. Thirdly, establishing contacts with trusted flaggers that are experts on this type of illegal content can also be very helpful. These bodies have priority when submitting notices, and many of them have put in place points of contact for collecting relevant input from users. So there is a list of trusted flaggers in the European Commission's website. Most of these trusted flaggers also want to receive input from users, so it can be a channel of cooperation for reporting harmful content. This was an initial presentation about DSA in general, how DSA can support the effort that we are discussing today. And I'm happy, of course, to discuss in more depth, taking also questions from the audience. Thank you.
Thank you, Ioana. That was wonderful. And we do have lots of questions for you. I'm going to move on next to Andronikos. Andronikos, I believe you have a presentation as well.
Yeah, I think you can see the browser. It's much easier to present in browsing mode because there are so many pages. So just as a summary, I would like to point out the confusing situation right now as the European Union is moving towards greater sensitivity and standards regulation about matters such as hate speech. Unfortunately, very large platforms, including both Meta and YouTubers we see just a few days ago, have started moving on the opposite direction, influenced by the situation right now in the United States. So, there is a kind of battle there between the two regions, and we hope that the DSA will serve to put a stop to this backpedaling. So to clarify, in YouTube, just a few months ago, if I recall, like more than 20% of material of a video was infringing, the video had to be taken down. Right now, it has to be over 50% if it is about some socially important matter. But someone can spread hate speech and disinformation about a specific incident that could be considered socially important. And instead of this having the standards going higher, now we are going lower. So it's a very good thing that we have this event and people learn more and more about the DSA. To clarify as well, my expertise, my background is indeed in fact-checking. Trusted flagging is a quite new area that has overlaps with our field, but I consider fact-checking the primary tool, perhaps, against the root of the problem in hate speech, in Islamophobia, things like that, because laws can act only in very targeted matters. To be able to make a report as a trusted flagger, to take down a post, it has to be quite extreme. It depends on the law of each country. In Greece, we have to, I can show you the laws, but we just don't need to take that much time. But in Greece, you have to have a post that brings people in danger of physical harm or social unrest. The level of the detail and evidence you have to provide is quite high for a platform. But and also it is relatively rare to see cases of such posts, but it's much, much more frequent to have cases of disinformation that try to dehumanize people. And there, as fact checkers, as our primary, I think, suit, we can call it, we can be even more effective in general. So I have here a report, from a European network that shows how immigration is becoming a quite important issue. Even after 2015-17, that was like the top, of interest on the issue due to refugee flows. It still remains at about the third, you can see it in orange, at about the third level of importance along disinformation matters. So it's still very important. And I was thinking that the first step then that you can take if you consider that you see disinformation on these subjects is exactly the European networks of fact checkers. You can search about your country, find in your region or especially in your country the related organizations networks, and you can try to contact them right away. So first of all, we have EDMO, the first initiative of the European Union. Here we have a list not only of fact checkers but also of institutions that cooperate with fact checkers. So it's a very good initial list, even for civil society organizations that would like to find partners or make a direct request about a certain situation. Then we have EFCSN, the second network, which is only for fact checkers. So you can very easily see the countries of each organization, and all organizations in the EFCSN and NETMO have to have very easy contact details. They should be available in all channels. It's very easy to send them something, even without details. Even if you just send them a link, they will check it out. So it's a very practical way to combat much of the problem. Also, the previous network that I said, EDMO, has hubs which are cross-national, but in a single region, not cross-European. So they know the details of your region in general even better. So in Greece, we have the Mediterranean Observatory, which I was also one of the founding members of. And these organizations do very good holistic work. They don't have only fact checkers, but also universities, etc. So if we leave this first approach and go to illegal, plainly illegal content, what can we do? So the first thing to know is that right now, all the large organizations or the large platforms called VLOPs have to provide an easy way to flag illegal content. To be frank, they try to do this as hardly observable as possible. They hid the option in a very obscure area of their platforms. So if you search for illegal removal request, you can find this forum, which was previously the only way to present, an illegal claim to the platform itself. But right now, if you go to the three, dots, you go down to report post, you can see a report as unlawful. Now, this has not been fully, fully clarified, but it seems very likely that this should be registered in the same way that a legal request form is. So if you go here and report it, exactly, the platform has to review it by person and one by one case. Why don't I mention the rest of the cases? Because in our first report, we detailed how the companies do a very, very bad job of moderating their platforms. So just selecting any other option, you can see here violent, helpful, disturbing content. This, in the vast majority of cases, won't go to a person. It will go to an algorithm, which we showed is not effective at all at detecting stuff, and it will not be practical. So you have to report it that way, as unlawful. Now, what happens if you report that way and nothing comes back? Here we have to go to proper trusted flagging. So as Ioanna said, we have a platform of the Commission that hosts all the accredited trusted flaggers, and you can see here all of our details and our expertise specifically, because not all flaggers are accredited to flag any kind of instance. So I did a quick summary, and I found these organizations that are flagging violent or hate speech. It's quite few for now. You can see Finland, Romania, France, Greece. So generally, an organization is only accredited for their own country. As FactReview, we're doing our best to expand our expertise and languages, but for now, here are the countries you can directly refer to. What other thing can you do? Before this institution of trusted flagging, there was this concept of internet hotlines, organizations that, they can record potential legal cases, perhaps they can refer to the police, and many of these organizations are also trusted flaggers, but not all. So this is a very good, again, repository of organizations that you can call in such a case. Now, there are so many links I know. We plan, along with CSOH, to develop a guide that detail the whole situation, so you don't have to remember everything I saw. And as FactReview, we recently provided our first public report about our flagging. We also had a presentation in the European Parliament which focused on fraud. And indeed, we see that this is the number one concern of illegal materials. So in our first proper reporting, that we explained what flagging we did to which platforms and how they responded, you can see that nearly all the cases, I have somewhere detailed, but nearly all the cases were about some kind of fraud, either financial, medical, of this kind. Illegal hate speech is quite easy, quite hard to find and flag that way. But of course, it also depends on the network of organizations and the public you are in contact with to let you know of these infringing posts. So we also consider it very important these kind of events and partnerships to be able, to have a wide contact base to locate hate speech, especially campaigns of hate speech, the number one concern. So here I have the law of hate speech. We have a repository of all the related laws, and we, as flaggers, you have to be very careful of the exact specifics of the law, which can change in another country. For example, without me being a lawyer, from my understanding, in Germany, you have a wider area of action because you can infringe on honor if you say this nationality is dirty. Perhaps in Germany, you can flag it, whereas in Greece, it's more, it's a gray area. So we're still in the first steps of this complex situation, and we're doing our best, uh, to learn the laws in detail, to develop partnerships, etc. Okay, I think as a first introduction, that is enough. It's a lot of information, and I'm available for anything else in the questionnaire.
Thank you so much, Andronikos. Nicholas, will go on to you next, and we do have questions lined up already from the audience, so go for it.
All right, great. Yeah, thanks for having me, and thanks for the great presentations, Ioana and Andronikos. I think I will just build on them. I also prepared a presentation, repeat some of what was said, but really build on it. I think one thing that is really helpful from what you have shown, Andronikos, is also this new mechanism for users in order to report content. Right, and you showed you can report content for potential violation of terms and conditions, such as hate speech or bullying and harassment or so forth, or you can report it for potentially constituting illegal content, for violating criminal law perhaps or other laws. When you do that as a user, you get a response from the platform. In both constellations, you should get a response from the platform. And that response will either be that the content is going to be removed following your report, or that the content is going to be left on the platform. When you get this leave up decision, basically you have reported something that you think is terrible content, either violating terms and conditions or violating the law, but then the platform says, no, we're not going to remove it. Then the question is like, what happens next? What can you do then? And that is really where out-of-court dispute settlement bodies come in. When you get this leave up decision from a platform, you can complain against that decision. And that you can do with out-of-court dispute settlement bodies. And so what are these out-of-court dispute settlement bodies? So these are organizations such as ourselves called user rights. And we are certified from a digital services coordinator in order to be able to accept these disputes. And everyone can report pretty much, everyone in the EU can report any kind of content When they get a leave-up decision, they have the right to come to us as an out-of-court dispute settlement organization and for free get a review of the decision of whether what the platform has decided was correct or not. So what we do when someone complains about a leave-up decision from a platform is to make a pretty thorough legal assessment of whether the decision by the platform not to remove this content that against the relevant law or against the relevant terms and conditions, depending on what you have reported it for. And we can do that for free for anyone who files a complaint with us, because platforms have an obligation under the law to work with us and to carry reasonable fees for it. And the added value that we hope that we provide for users is to get this very thorough review and to potentially make corrections through that. We also think we provide an added value actually to platforms because we do a more thorough review than whatever they do in their review. I think, as Andronikos, you have said, often when you report content to a platform, they might do some sort of automated analysis. It's often not very good and it's often not correct. So that doesn't happen when you complain against that decision pretty much to us, because then really lawyers are looking at it. What happens when someone submits a case to us is that we basically request the relevant information from the platform, then we make the legal review, and then we share the results with the complainant and the platform. And again, the platform has an obligation to cooperate with us in good faith. And we think that also includes implementing the decision when there's no good reasons not to do it. So decisions are not as such in every individual case binding, but generally there is the obligation of platforms to cooperate with us in good faith, and we think that is also implementing the decisions. Maybe it could be interesting to look at some numbers. So I'm just going to share some of the slides that I have prepared, and I want to share this slide, for example, in particular. So this is basically a slide which provides an overview of the kind of reports that are filed within the mechanisms that Andronikos has also presented. So what we see here on the left are reports that have been submitted for potential illegality of content. And if we even just look at one area of that kind of these kind of reports that have been made, such as defamation, we can see that in 76% of the cases, these reports are unsuccessful. This is based on the numbers reported by Meta themselves for Instagram for a certain period of time, for Q4 2024. What I think is also interesting is that when you report something for potentially being illegal, here in 35,000 cases, something has been reported for defamation, then if Instagram decides to remove this content, they usually do it based on the terms and conditions and not actually based on the potential illegality, but they do it based on the terms and conditions. And that is also only in around like 24% of all cases. What we see on the right-hand side are reports for based on terms and conditions to platforms. So what we see here is that around 609,000 times in Q4, content has been reported by people for Instagram potentiating terms and conditions. And in 115,000 cases, this has led to the removal of that content. That means that also in almost 500,000 cases, these complaints have been unsuccessful. That's in 82% of all cases where a report has been filed. Whenever that happens, that you report something, if it's for illegality or it's for terms and conditions, and the platform does not remove it, which we can see is the largest part of the cases, then you can basically appeal to user rights. And I can also quickly share some numbers of how our procedures look like and what the outcome is. So in total, since we started operating, we have received around 123 complaints relating to the constellation that someone has reported content and then it has not been removed. And here we see then the outcome of these procedures that they had for our dispute resolution body. First thing to note is the reversal rate. at the bottom, which is around 53%, largely because of TikTok. And what happens here is that when we contact TikTok and we only notify them that someone has complained against their decision to leave this content up, they re-review their original content moderation decisions. And interestingly, in more than half of the cases, they actually come to the result that they made an error in their assessment and they directly remove that piece of content, because then the review probably doesn't end up in an automated system anymore, but they actually review it. That means in half of the cases where someone then brings a case to us, TikTok directly reverses the decision after we contact them initially. Where that doesn't happen, then we make a thorough legal assessment of what the outcome is. And then you can see here under report justified and report not justified what the numbers are. And interestingly, for Instagram, you can see that actually in all cases, the report has been justified. For TikTok, you can see that in 19%, for 19 cases, like the report has been justified, while for 34 cases has not been justified. So I hope like these numbers give a bit of an impression of how this tool of out-of-court dispute settlement really adds to other reporting mechanisms that can be used by ordinary users, but that can also be used by trusted flaggers. Because trusted flaggers, for example, they can report content to a platform in case they don't take it down. A trusted flagger can also submit the case to an out-of-court dispute settlement body in order to then get this additional review. And so that's why I think having this event also here is extremely helpful, and having different kind of organizations taking part in it. Because I think it sees like how actually different aspects of the DSA really complement each other and build on each other. And maybe one last word, specifically with view to hate speech also against communities which might be outside of the European Union. So generally, in order for us to start a procedure, the case really has to be initiated from within the European Union. That means that people outside the European Union generally cannot rely on this process. However, anyone who is in the European Union can technically report whatever content they want, and that can also be hateful content against any sort of community globally. So that means that when there's hate speech against certain communities from, let's say, Southeast Asia or something like that, and it's reported by someone in the European Union, then this is a case that we can also review. And with that, I would also just stop here. And yeah, thank you already.
Thank you so much for that, Nicholas. Thank you. We have lots of questions coming in from the audience, and I have some questions as well. I would like to ask Ioana a question first, if that's okay. Ioana, could you speak to the role that DSCs can play in identifying and stemming hate emerging from outside of Europe, like from places like South Asia? How can diaspora communities, particularly South Asian and Southeast Asian diaspora communities in Europe, better work with DSCs to help them contextualize the hate that they face?
Thank you for the question. These aspects have somehow been covered by what I described before, but it's quite important to note here that the DSCs, the Digital Service Coordinators in the 27 member states of the European Union, are not the ones that identify and analyze the illegal and harmful content, but they are the ones that monitor whether the DSA processes are implemented properly and that the information about systemic risks reaches the European Commission, which is in charge of the monitoring of very large online platforms and very large online search engines. We monitor as DSCs the obligations set by DSA, but DSA is not the regulation that defines what is legal and what is not, what is illegal. So, as I have already mentioned, people comprising the diaspora communities in Europe of South Asia, Southeast Asia, should use the opportunity to submit the notices to platforms and their complaints both to the platforms and the DSCs. Being aware of these issues, both at platforms and DSCs level, can contribute not only in the ad hoc removal of the illegal and harmful content, but also support the risk mitigation efforts of the systemic risks associated with the promotion of hate through the digital platforms. In addition, as mentioned, these communities should seek to get support from civil society organizations and trusted flaggers, because this type of institutions have a special role within DSA and can bring results against illegal content.
Thank you for that answer. Under Nikos, we've seen how disinformation campaigns targeting diaspora communities often follow predictable patterns. They start with dog whistles in diaspora languages, escalating during political events in their home countries or countries of origin, and then explode into mainstream hate speech. Given FactReview's experience as Greece's first DSA trusted flagger, how do you navigate the tensions between acting on early stage coded content that might not yet be clearly illegal versus waiting until it crosses that threshold, but potentially allowing harm to scale?
Yes, that's an important problem because it's much easier for the malevolent actors to, exactly as you said, have dog whistles to cause harm, but you can't, at least very apparently, categorize it as illegal. So in this case, we personally, as experienced fact checkers as well, we prefer to act on this part in the first, level, especially if we detect a campaign, even if it is a kind of a whistle, we can communicate with our partners across Europe. We are parts of networks, so I believe, debunking and on a second level, still the very large platforms in Europe have some kind of mechanisms. There is still, for example, fact-checking in Facebook in Europe, which is very good at containing hateful misinformation, putting labels. And so this is our first approach. We can act as flaggers only once we have quite apparent cases of illegal content. I understand that this is a hard balance to keep, but for now, this is the way.
Thank you. Nicholas, most users do not tend to think beyond reporting to the platform. So, especially in contexts like South Asia, given the diversity of language and cultural contexts, most platforms fail to act on reports. Could you speak to us on how you envision out of court dispute settlements to be helpful?
Yeah, absolutely. It is a huge issue that we see, that people often simply don't know about these rights, which I guess is understandable because many of them are relatively new, but still we have to do and get active now in order to inform people about their rights so that they really can exercise them effectively. There are a few pathways which I think are really important. One is platforms actually have to inform users about their rights when making these content moderation decisions. So when you get the decision that the content that you have reported will be left on the platform and will not be removed, there's actually a legal obligation that they have to inform you about your rights to also go to an out-of-court dispute settlement, for example. This doesn't happen yet. Many platforms don't do it yet. And that's why people at this point, then they don't really know about that, right? So that is a problem. So we're working on that. I think the second thing that we really want to be working on is to connect with civil society organizations, also with trusted flaggers, in order to better inform different groups, NGOs, and then also communities that these rights exist and that they can use them. We also want to speak with people, perhaps on social media, if you have certain influencers or accounts that are relevant in a certain region that try to help educate people and communities about these rights, or generally try to support them, then we're going to hope to work with them so that they can also inform their their followers and so forth that these rights exist, that they're free of charge, and really you should try to make use of them. So basically, we're just going to try to spread the word so that people understand this is quite a nice opportunity, because you can get a review of your rights for free. You get a thorough legal assessment, and we know that it really matters to people. So the challenge is really like trying to reach them.
Sorry, I just have a follow-up question for that. So if an individual user is planning to approach a dispute mediation body with regard to hate speech or disinformation that emerges from outside of Europe, what specific issues should they bear in mind when approaching?
I think the main issue that they should bear in mind is they have to check also whether the dispute is in scope for the relevant out-of-court dispute settlement body. The European Commission provides a website that lists different out-of-court dispute settlement bodies, and that also defines what is really in scope for these organizations and what is not in scope. And for user rights, we, for example, review most of the terms and conditions that are provided by platforms, including hate speech and so forth. So that's really important. But for example, we don't cover all languages yet. We don't cover Greek, for example, yet. So right now we do English and German, and soon we'll do probably French and Italian. But other cases, might be out of scope because of the language. So it's important to also figure out what body is actually really competent a particular path. Again, here, I think ultimately it has to be made as easy as possible for the user. So we need a better website from the European Commission that makes it easy to understand, like, what is happening, where can I go? And maybe also have civil society organizations supporting that to a certain degree, that you have some sort of one go-to place where you can then figure out where can I actually take my dispute. And other than that, I think it's just important that everyone knows that really you don't have to do that much in order to submit a dispute like this. We basically ask you to provide some general information around it. We ask you why do you disagree with the decision, and that's literally it. And so I hope that the burden is not that high ultimately.
Thank you so much for that. I have more questions. However, the audience also has questions for you as well. I will go to our first questions. The first is, can you comment on how content removal will work in encrypted spaces like WhatsApp? Putting that question out there for all of our guests, whoever wants to answer. Should
I
I choose
know
someone?
some things around this problem, because it's a very controversial question. On the one hand, you have privacy, which is a bedrock of democracy, etc. On the other, we know the problems of illegal content. So right now, I think the Commission discusses what will be the exact regulation about allowing the encryption to break in some cases. Specifically, there was a very controversial situation last year for sexual abuse material. But it's very hard for all the authorities to agree, both countries, the Commission, because exactly you can't have it both ways. So right now, I don't think there is like a specific answer for that. Perhaps Ioana knows more, or we need some very specific expert for that.
Yes, I can confirm what Andronikos said, that this is still an open issue. This is still under discussion because it's a sensitive issue because of the freedom of speech and the freedom of expression. So still, we don't have something more specific about encrypted services and encrypted messaging.
So the next question is, can a user outside of Europe contact a trusted flagger if they identify volatile content like disinformation? What would be a method to do that?
I can try cover that, and Ioana can also offer her perspective, or you can offer it now even. Still, it's a very evolving situation, but my understanding is that social media, very large platforms are interconnected. So seeing some material while being in India, it's the same visible material in Europe. So if it's in the language of a fact checker, so if it's in Greek in my case, it's okay, it's a very rare language, but if it's in English, which is the language of Ireland, I believe you could contact a trusted flagger in Ireland that could flag it according to their understanding. Ioanna can also offer her perspective.
Yes, this is of course feasible because, as Andronikos said, the content is everywhere the same. Of course, there are some restrictions, some national legal restrictions, so some content is not seen in Italy because it's particularly illegal there. We know, for example, in Italy, let me give you another example, different from what we're discussing today. Advertising gaming is prohibited, so there is no advertising of gaming in Italy. So someone cannot report an Italian trusted flagger that is specialized in gaming for Italy cannot report something that someone sees in India. But in general, when we discuss about hate speech, which is not very easy to have a uniform guidance on whether it is illegal or not. As Andronikos explained also before, there are some blurred lines on this between the different countries. So, of course, it's feasible from someone outside EU to use a trusted flagger that is located, that is established in EU to report something. And then the trusted flagger will examine this, but of course, every trusted flagger has expertise on the national law of its country of establishment. It might not be very easy if it's something very specific to reach conclusions, but they can try, and we believe that the trusted flaggers we will make their best to deal with it.
Nicholas, one of the audience members has a question for you. The question is, when you're investigating content in non-EU languages, example, Hindi, how do you make sure that you have the linguistic and contextual knowledge to adequately assess content, especially as we know that a lot of hate speech includes coded imagery and dog whistles?
Yeah, I think that's a great question, and it's a huge challenge. So we are still relatively early stages. So what we currently do is we only review content that is in German or in French, in German or in English. And the reason for that is because of the importance of context and because of the importance of understanding also the nuances of the language, as well as having the context of the relevant, region where this content might be relevant. So we do not work with translations of the content. And we still have to figure out how we want to approach this in the future, because we have some out-of-court dispute settlement bodies which would also work with translations. So for example, then just translate the relevant content and then basically review that translated content. And we think on the one hand, of course, that allows to take on more languages more quickly, but it doesn't solve the problem then that was raised by this, very important question, which is like, how you cannot probably not just translate something, have no understanding of the nuances of the language plus the context, and then make a content review decision based on that. So our approach at User Rights is that whenever we review content, is we want to have people review the content in the original language. That means that they, have an understanding of the language, then also of the context, and with that, hopefully also of the region, in order to make the assessment of whether it's violating or not. That means that it's going to take time for us to onboard all kinds of languages. And currently, as I said, we're in the state where we work with German and English content, and soon we want to do like French and Italian. And then basically based on that, we want to try to onboard more languages. But for us, this also means to basically onboard reviewers who are ideally native speakers in these languages. And that for us is really going to take time, which is also not ideal, but we just thought we otherwise can't solve the problem of accounting for context adequately.
Thank you for that. We have lots of questions coming in, so if I could take a few more minutes of your time. We have a question that asks, what advice do you have for diaspora civil society organizations on building long-term evidence of platforms allowing harmful content? How can this evidence be effectively used over time to build a case for regulatory enforcement or legal action under the DSA? So I'm throwing that question out there to you.
I can take this question. As I already mentioned, civil society organizations are part of this ecosystem of the DSA implementation ecosystem. They are consulted by the Commission about systemic risks, but of course, all the evidence have to be supported, all the observations have to be supported by evidence. So the advice would be to keep evidence of what is considered harmful, what is considered illegal, in order to present the patterns in the effect that these posts have for the audience. So the Commission is open to receiving feedback from CSOs, but of course, it should be evidenced. It should be based on practical evidence and on information that has been collected, screenshots, of course, analysis on why this is harmful, so it can easily fit their work, the Commission work.
I also have a couple practical notes. In our first report, we focus exactly on how the platforms don't really moderate, don't even hold their standards, that they have already stated. So I believe one of the best pieces of evidence is to show that we reported, let's say, 100 pieces of content and the platform took down only 5%. This is hard evidence, I believe, of how this doesn't really work. And another thing is randomized, searches to show that we didn't just find one piece of content. I made a new account and searched like a common, let's say, user and found in 100 posts so many instances of hate speech. So if you show statistically that there is a significant percentage, that is another piece of evidence. And there is also advertisements. It's a long situation. I can send you to see our first report on the subject and how you can watch the advertisements on the platforms and how they could also infringe.
Thank you. Another question we have is, given the increasing influence of right-wing parties in Europe, curious to know if there are any ways, loopholes that the DSA can be misused to suppress dissenting voices or minority opinions, including diaspora communities, under the pretext of combating illegal content. Are there any indicators of such misuse now or in the future?
So out-of-court dispute settlements bodies actually work in both directions. So whenever you report content and it's not removed, then you can complain against that. But whenever there's a content moderation decision that restricts your content, removes your content or removes your account or demotes it, restricts its reach or something, you have the same right. So then you can also take that decision that you get from the platform where they say, we are going to demote your content and restrict its reach because we think it might be violating this or that policy. You can take that, go to an out-of-court dispute settlement body, and then complain against that decision too. So basically, when it comes to the risk of the speech of certain communities being over moderated pretty much and too much restricted, then you also have this mechanism of getting an independent review of that. And that is I think then one concrete step that could be taken by people. And then we are also going to do reporting that is, going to build on the kind of reporting that Andronikos also spoke about. Like, we also want to report is like, what is actually the outcome of our cases, right? Let's say we have 1,000 cases relating to hate speech, for example, that we review, and then we can perhaps track certain meta areas or even different regions or languages in which this content was posted. And then based on that, we can have like a quantitative analysis of actually how often we think platforms get the content moderation decisions right in different languages with view to different policies and so forth. And through that, hopefully also contribute to a better understanding of when moderation just doesn't work very well or there's too much moderation.
Thank you. There's another question, Andronikos, for you specifically, and then Nicholas. The question is, could you explain a bit more about the engagement between trusted flaggers under the DSA and the platforms? Specifically, is the expectation that you provide evidence supporting the removal of content, and do the platforms typically still have someone review the content themselves again after that?
Yes, flaggers, by definition, just flag to the platforms and the platforms have to expeditiously, they have to prioritize our review, but they still review on their own. And personally, I very much agree with that. We shouldn't just be judges of everything. So yeah, the important thing there is that, in my understanding, there should always be a person, not an automated system, because we have seen automated systems make so many mistakes. And yes, so we have a form that we detail the URL, the explanation, our investigation. We try to be as thorough as possible, and then we try to detail the laws in our nationality that infringe, that this content infringes. So this is the summary of how it works. And generally, until by now, and Meta does their reviews quite fast in a couple days, many times. So it's practical for now.
Nicholas, is there an urgent procedure mechanism for instance in situations where timing is important, such as during elections?
I can also take this question to give
Please.
the Commission
Of course.
perspective, but after Nicholas. So
No,
Nicholas, if
please
you
go
want to
ahead.
start.
Go ahead.
Please, I want to.
During the elections, the European Commission, together with the platforms as well as the country authorities where the elections are taking place, are formulating a task force that is monitoring very closely and having regular meetings with the platforms in order to ensure that there is no interference in the election process. A DSA election toolkit has also been published that has to be used as a best practice tool on behalf of the coordinators in every country that elections are taking place. So there is a mechanism in place for election processes. And there is also a discussion within the DSA board where the Commission and the digital service coordinators participate about these incidents, about this crisis that might happen. And there is also a relevant article in the DSA that describes this is more on a voluntary basis, but it describes the added value that this kind of incidents response mechanisms can bring. So all these are under formulation. The election has been put in place many times until now, because we had a lot of elections in Europe since April 2024, when the DSA got into force. So for the election, it has been used quite regularly. For incidents, it hasn't been used so often, but it's in the process of being streamlined.
Maybe very briefly for us. So generally, complaints can also be brought by organizations under Article 86 of the DSA, which then would probably allow for a certain prioritization. We are dealing with the question of whether we can prioritize disputes based on the subject matter area we are still like working through that. So, you know, still a lot of questions are unopened, and we basically want to balance treating everyone fairly, but also then responding to some sort of urgent incidents, perhaps. So I'm not quite sure yet how actually we are going to do it and how it is going to work.
So I believe Stamos wants to speak, Nicholas, as well. He wants to answer a question, so I would invite him to come as well. He is also from your organization. Stamos, welcome.
Hi, can you hear me?
Yes, we can.
Perfect. Yeah, it's just a small note in the previous question that Andronicos has already answered, but it was just a small note regarding the type of cooperation existing between trusted flaggers and VLOPs, specifically the evidence supporting the removal of content. And each report that we submit has to contain the legal precedent that we use in order to take down the content. For example, I can just go on and just submit a report and say it's illegal because I said so. So I submit the relevant screenshots, the documentation of why this potential piece of content is problematic or illegal, and then we submit the specific law pertaining to this case, why this content is illegal in Greece. So yes, there is a full documentation. There is an examination from the social media side, of course, but most of the times in our experience, the response is positive and it comes within 1 or 2 days.
Thank you for that, Stamos. I appreciate it. Stamos is also with FactReview with Nicholas, and we do have some more questions. I'll just take a few more, 2, 3 more before we
Very
end
quickly,
this.
Niana, I'm not actually from FactReview, but
Sorry, I apologize.
no
Andronikos,
worries at all.
I apologize. We have another question from one of our participants. Given the legal requirement to remove content when there are reasonable grounds to infer that it is illegal, how does your service determine the illegality of content, especially when it involves assessing the mental element or intent behind the user actions, which is notoriously difficult to evaluate in online contexts lacking full evidence or nuance?
I understand this is referred to my organization. Yes, so we don't examine intent. This is not about intent, and as I said, we have a very high standard for what we would consider to flag. This should be, I believe, a very apparent breach of a specific law. And as Tamus clarified just a while ago, we have a full list of laws, and we have to tag the exact laws. In our report, we have made public a few days ago, and you can see our exact reports to the VLOPs themselves. So you can see how detailed is every explanation. And of course, the platforms don't want to take down anything without good reason, so they double check. And right now we have outside legal, help about such cases and related questions. And in the near future, we hope to have inside our organization legal support about very very small details, nuanced cases, etc. So we are very careful about that.
Okay, I have one final question, and then we are going to round up our discussion. Do you believe the community note system, as used by Meta in the USA and Twitter, which relies on contributions from an undefined group of users, can effectively replace traditional fact-checking, considering the risk of it becoming a tool for spreading popular but potentially subjective or ideological biased narratives?
I can also take that because it's become like one of the top subjects of discussion in my field over the past few months. My view is that certainly notes of some kind and cooperation with the public of the users and the platform of some kind is useful. As fact checkers, we always want to get information for the public. That's the primary way that we know about infringing content. But the way it's been implemented in X, and right now Facebook also rolls this out in the USA, is very problematic To give an example, even in undisputed cases of facts, if one side doesn't want to recognize the truth in any way, a note will never be shown to the public. There have been a series of research reports, thorough reviews. They all show this pattern. Most of the notes don't appear. Many notes cite to our own fact-checking of accredited organizations. Quite a few notes are problematic, are biased, or are just very short because, these platforms don't allow for full analysis like our articles. So this is a good system to be used in cooperation with experts. My own organization has also provided a thorough, proposal about how this can work. But right now, the platforms try to replace professional fact checkers just to, I believe, they save on money, and it's much easier for them to say, I don't have anything to do with the truth, the public knows the truth. It's much easier for them. But it's good right now that the DSA, with the code of practice on disinformation, makes such explanations very, very, very uncertain. And I believe the Commission in the following months will have some conclusion about if community notes can indeed replace us. We will see about that.
Thank you so much. And thank you to all of our speakers and to everyone who joined us today for contributing to this important conversation. Today's discussion highlights the urgent need to address cross-border hate and disinformation that may originate outside of Europe, but has real and often very real and dangerous consequences within European communities. We hope that this event sparks deeper collaborations between organizations in Europe and South Asia and strengthens the infrastructure needed to mitigate these online harms. If you're interested in continuing this conversation or connecting with any of the speakers, please do not hesitate to reach out to the center via email. Thank you again for being here, and we look forward to building on this momentum together. Signing off. Thank you so much.
Thank you so much.
Thank you so much as well.
Thank you.